Our second panelist is an international human rights lawyer and professor, and the inaugural holder of the Massey College Chair in Human Rights. Professor Akhavan is a member of the Permanent Court of Arbitration at The Hague, an associate member of the Institut de Droit International, and a special advisor on genocide to the prosecutor of the International Criminal Court. He was the first legal advisor to the prosecutor's office of the International Criminal Tribunal for the former Yugoslavia from 1994 to 2000. At The Hague, he has defended genocide survivors throughout the world, including the Baha'is of Iran, the Yazidis of Iraq, and Myanmar's Rohingya minority. He also serves as a senior advisor to the Ministry of Global Affairs of Canada and as a member of the advisory panel on the Ukraine International Airlines flight PS752. Before I throw to Mr. Akhavan, I just want to remind people who are joining us now, if you do need translation from English to Persian, please go on the globe icon just at the bottom of your screen, click on it, and choose your preferred language for simultaneous translation. The title of Payam Akhavan's talk today is Building a Culture of Accountability. Payam, the microphone is yours. Welcome.
Thank you very much, Samira, for your kind introduction. And I'm honored to have been invited to this panel with dear friends and distinguished colleagues. I thought that I would share some brief thoughts about the very idea of transitional justice, and then to speak a bit about some of the building blocks with a particular focus on the situation of Iran. Firstly, an essential point in respect of transitional justice is the notion of state criminality. Typically, when we speak about criminal justice in a democratic society where there's a rule of law, separation of powers, and independent judiciary, we have what is called habitual lawfulness. So, for instance, most people in a democratic society do not commit murder, they do not engage in acts of violence, which is why the criminal justice system focuses on deviance from those habitual norms and prosecutes isolated individuals for committing crimes. And the purpose of the criminal justice system is to reaffirm the existing norms of society, to instill subconscious inhibitions against violence. Now, the problem with state criminality in an authoritarian system is that there is an inverted morality in which acts of murder, torture, persecution on grounds of political or religious belief, imprisonment, what have you, are in fact expressions of state policy. And in many cases, violence, let's say, against protesters in the streets are glorified as acts of preserving the revolution, the ideology of the state, or what have you. So the problem with transitional justice is a multiplicity of crimes. We're not speaking about a handful of murders or acts of torture or sexual violence, but we're speaking about widespread or systematic attack against the civilian population as a matter of state policy, which in fact is the definition of crimes against humanity in international law. So the purpose of transitional justice in that sort of context is to bring about not just satisfaction to the victims, vindication of their suffering, but a wider transformation of social mores to turn this inverted morality right side up and to send the message that violence, revenge, and what have you are wrong, and to instill those inhibitions and those values which become the building blocks of a democratic society based on respect for human rights and the rule of law. The second point is that the idea of justice is not limited to criminal justice. Very often we speak about punitive justice. We speak about the prosecution of those that are responsible for crimes against humanity, putting them on trial or what have you. But other than punitive justice, transitional justice must also encompass restorative justice. One aspect of restorative justice can be truth commissions, for instance. Dr. Abedian was just speaking about the example of South Africa, the Truth and Reconciliation Commission. Restorative justice can also include compensation for victims of human rights abuses. And more widely, it could include the commemoration of past injustices, the recognition through museums, through public apologies by heads of state and governments, through the transformation of the educational curriculum, the way in which children are taught history. And it's important to understand that justice cannot be reduced simply to punishing those who have committed crimes, as important as that may be, because in a criminal trial, the protagonist, in fact, is not the victim. The protagonist is the defendant. A trial, criminal trial, is about the guilt or innocence of the defendant. And the suffering of the victims is only incidental to proof of that guilt or innocence. And one aspect of a criminal trial, of course, is first of all, that you can only have so many witnesses. You cannot have tens of thousands of witnesses who are the victims of systemic criminality, simply because it's practically not possible. And in any event, the testimony of victims is relevant only insofar as it relates to the guilt or innocence of the accused. So, for example, if someone is a victim of torture in a prison, and it is the Minister of Interior that is being prosecuted, that person may not be in a position to specifically identify who the perpetrator was, because very often with systemic criminality, the perpetrator is not the torturer in the prison, is not the prison guard, but someone much higher up the chain of command who's responsible for formulating that policy or ordering subordinates to commit that crime. So this disqualifies a very large number of victims from participation in the criminal justice process. There is yet a further dimension of criminal justice, which is not ideally suited to victims, which is that the defendant has a right, through the lawyers representing the defendant, to cross-examine witnesses, to impugn their credibility. So very often, victims of trauma are re-traumatized, reliving their experiences in court in a context where the defense lawyer is not going to be friendly to them. The defense lawyer is there to very aggressively question their credibility, question whether they're telling the truth. So this is another reason why restorative justice is so important. Truth commissions are victim-centered. They are not perpetrator-centered. And truth commissions, as in South Africa and other contexts, allow for tens of thousands of victims to come and tell their stories in a context where what is at issue is their experience, their suffering. There is no adversarial process, there's no cross-examination, and so on and so forth. And for instance, a mother can come and speak about her grief at the loss of her child, rather than having to identify whether the accused in a particular trial is responsible. So we have to have a holistic idea of what transitional justice includes, and not limited simply to the prosecution of this or that perpetrator. And this brings me to a third point, which is that when we speak about transitional justice, There is, of course, the immediate idea of a transition. If a society is emerging from war or armed conflict, there will typically be a peace agreement, a peace process, and then the question is, how does one address, for example, war crimes that may have been committed in the context of that armed conflict? In the context of a democratic transition, a transitional period is when there is an agreement, as there was, for example, in South Africa, to put an end to apartheid, to hold democratic elections, or as was the case in Chile or Argentina or many other countries, where let's say a military regime or another form of authoritarian power agrees to relinquish power, or there is a collapse of the state institutions and new institutions are being created. So it's very difficult to say in the context of Iran that we are, in the immediate sense, in a transitional period. But it's important to bear in mind that there is a broader historical transition which takes place as a population which is being subjected to hateful and violent ideology and a culture of authoritarianism gradually becomes aware of the notion of human rights, of the notion of dadkhahi or demanding justice. And we must bear in mind that most people in authoritarian states have no idea what the rule of law looks like, what an impartial and independent court looks like, because all they have seen are revolutionary courts, kangaroo courts, which are essentially political show trials. So this is where we have to understand that building a culture of human rights and educating and empowering the public to understand and demand justice itself is part of the struggle that at the appropriate time can result in transitional justice in a more immediate sense, to ensure that one is genuinely moving from authoritarianism to democracy rather than simply perpetuating endlessly the cycle of violence and revenge. My final point is to reflect a bit on some experiences I've had in the Iranian context, in the context of the democratic struggle of the Iranian people. The first relates to the 1988 mass executions of an estimated 5,000 largely leftist political prisoners who, in the space of a few days at the end of the Iran-Iraq war, were executed pursuant to a fatwa issued by Ayatollah Khomeini, and who were then buried in secret, including at the Khavaran website to the southeast of Tehran. And the mothers of Khavaran, as they became known, which who resemble in many respects the mothers of the Plaza de Mayo in Argentina, for example, who demanded justice for their loved ones, for their children, began a movement demanding justice for their children who had been executed. And in 2012, a group of us who were approached by the mothers of Khavaran asking that a case be brought against the Islamic Republic of Iran before the International Criminal Court, who had to tell them that the court has no jurisdiction in respect of Iran, because Iran predictably has never accepted the jurisdiction of the court, given that in international law, the principle of state sovereignty still prevails. States have to consent to jurisdiction. So instead of leaving these mothers empty-handed, we decided to establish the Iran Tribunal, which is a people's tribunal, a sort of truth commission in exile, where some 100 witnesses and survivors testified before a panel of eminent judges who were jurists of great reputation about what had happened in those horrific days in the summer of 1988. And these hearings were broadcast by satellite television, by social media, and we estimate that millions of Iranians, for the first time, learned about the mass executions of 1988. And this ultimately resulted in the Islamic Republic, finally, after some 25, 30 years of denial, to admit that, in fact, these executions took place, but then, of course, to legitimize it in the name of Sharia law, in the name of revolutionary principles, or what have you. But one point which is important to bear in mind is that one of the highlights of the Iran tribunal was one individual by the name of Mother Esmat, a woman by the name of Esmat who had lost 4 of her children. And she came to the witness stand and put the photographs of her 4 children on the table. And one by one, she began to recount their names and how they were executed. And as she was shedding tears, I noticed that in the room, everyone, people of all stripes, political stripes, ethnic groups, religious groups, were all crying together with Mother Esmat. And there was a moment of transcendent humanity where everyone felt the pain of a mother who had lost her children. No one asked what was the ideology or political or religious opinion or what have you. And that testimony probably did more to bring to the surface these horrific crimes than anything I, as a legal scholar, for example, could publish about what happened. So this popularization of justice very often is through the voice of the victims, through the voice of the survivors, through that moment of transcendent humanity. The space that was created in the Iranian public imagination following the Iran tribunal included a number of consequences. One was the rendering public the secret recording that Ayatollah Montazeri, the heir apparent once upon a time of Ayatollah Khomeini, had made of his conversation with members of the so-called Death Commission, which included the likes of Ebrahim Raisi, the former president of Iran, Ismail Shushtari, former Minister of Justice of Iran, Mr. Nayeri, Chief Justice of Iran. And here we had a remarkable instance of people hearing for the first time Ayatollah Montazeri telling the members of the Death Commission that what they were about to commit would go down in history as one of the darkest chapters in the history of the Iranian people. But one of the very significant consequences, other than this episode, was the arrest of Hamid Nouri in Sweden, where he was under the principle of universal jurisdiction, prosecuted, sentenced to life imprisonment, and unfortunately, recently, through a very disgraceful instance of hostage diplomacy, he was handed back by Sweden to Iran in exchange for 2 Swedish nationals who were essentially kept as pawns by Iran in order to ensure that Hamid Nouri could be repatriated. But nonetheless, the image of seeing the assistant of Ebrahim Raisi being prosecuted in a Swedish court, the image of a proper, impartial, independent trial, I think had very significant consequences on the popular consciousness of Iranians and their understanding of the notion of justice. Finally, this brings me to the example of the families of the victims of flight PS752 that was shot down over the skies of Tehran some 3 minutes after it took off on January 8th, 2020. Because I'm a counsel on that case, I unfortunately cannot say much about the case, but I do want to say that the reason why the governments of Canada, Ukraine, Sweden, and the United Kingdom, who all had nationals aboard this flight, eventually agreed to bring this historic case before the International Court of Justice at The Hague, where I have the honor of acting as counsel, was because the families of the victims refused to accept that there would be no justice for them. They organized themselves, they mobilized themselves, and they spoke truth to power. They steered the conscience, not just of the Iranian people, but also of the public in Canada, in Ukraine, and they succeeded in persuading these four governments to bring this historic case before the International Court of Justice, which is currently pending. These are just some examples, and I could provide many others if there was more time, of how we should not despair and imagine that unless tomorrow all those who are responsible for crimes against humanity are brought for justice, that there is no hope and that we should simply give up. Justice is a historical process, and fundamentally, it is about cultural transformation. It's about instilling in the minds of the Iranian people the very idea of human rights, the rule of law, of a cultural transformation. And those are the building blocks that in due course will help ensure that when there is a democratic transition, which is only a matter of time, that instead of repeating a cycle of revenge and violence, that we will instead be able to usher in a new era characterized by constitutionalism, human rights, and the rule of law. Once again, I thank you very much for inviting me, and I thank you for your patience in listening to my remarks.
Payam John, I know that you can't stay with us for the question and answer period. But before I introduce our last speaker for today, Ms. Mehrangi Zakar, we did get a question for you about transitional justice. So before you go, we just wanted to put that to you, if it's okay.
Yes, of course.
So we had a question, and it is, in transitional justice, it is possible that some officials from the former regime, while being held accountable for their crimes, can also assist in the transfer of power or the integration of insurgent factions into the new government. How would they be dealt with?
It's a very good question. And in different contexts, you have, for example, the peace versus justice debate in the context of war, where you need to negotiate with those who may have committed war crimes because they're in power and they are required to conclude a ceasefire. In the context of a democratic transition, you have the example of Augusto Pinochet in Chile, who agreed to surrender power from the military junta to a civilian government in exchange for an amnesty. So I think that every society has to gauge its particular circumstances in deciding what form of transitional justice is appropriate. And it remains to be seen how that transition would look like in Iran. But sometimes it may be necessary to make some very difficult compromises. But what is important is, at the very least, that the truth become manifest, that there is no collective amnesia. At the very least, victims and survivors should have the right to establish a historical record, and the public should become aware of the past so it can reckon with it and ensure that it is not repeated in the future. But ultimately, impunity, a culture of impunity, only breeds further violence. It sends the message that power is a license for abuse, which is why, in principle, one should not, if you like, confer immunity for crimes against humanity as a price to achieve democracy because of its long-term consequences.
Thank you so much, and thank you for your talk today.
Thank you.